So our guest speaker today is Joanne O'Brien, partner of CRH Law. Joanne has extensive practice in aged care and retirement living sectors, encompassing clients from both faith-based, community and private sectors. Thank you very much, Joanne.
Thanks, Kerry. Everybody, since we have got a limited time frame on, and I can't even get the slides to work. Is this turned on?
Oh, yeah, it should be.
Thank you. So, given we've got limited time, I'm just going to jump straight into it, and hopefully we'll have a chance for some questions at the end. Just some introductory key points. This new Notifiable Data Breaches scheme was introduced by way of amendments to the Privacy Act. So there's a little bit of assumed knowledge in relation to this presentation. That is that you know whether or not the Privacy Act applies to you and you're familiar with your obligations under the Privacy Act. The scheme really has its genesis, if you like, in principle number 11, which is your obligation to keep personal and healthcare information secure. There's been a 12-month lead-in time to this, believe it or not. The legislation was actually passed 12 months ago, the amending legislation, but there was a delay to the beginning of the scheme. It was only a part of the amendments that were introduced last year. So it kicks off from 22 February this year, hence you're all getting prepared now. The main role of the Australian Information Commissioner in the scheme is to receive the notifications, the mandatory notifications that you have to give under the scheme if there is a breach. There's no new penalties or new regulatory regime in response to your non-compliance. It's the same that's always been under the Privacy Act, and generally the Commissioner gets involved as a result of a complaint by a client or consumer that their privacy has been interfered with. The Commissioner does have the ability though in certain circumstances to actually direct you to make a notification. So if for example, a client was complained that their information had been accessed as a result of a breach of your systems, and you didn't actually comply with the scheme, then it's possible following an investigation that the Commissioner would actually direct your compliance. That's really the only new compliance tool that he has. And there, as always with new laws, there are some exceptions. What I'm going to talk about today are the ones that are likely to be most relevant to you. There are a raft of technical exceptions that really relate to our security enforcement agencies at the Commonwealth level. So I'm just trying to, maybe if you can change the slide for me. So just to give some context, because it's easy to see, you know, in aged care, yet another mandatory reporting regime and to think, here we go, we've got a whole heap of new red tape. But I think you really need to consider these new requirements in the context of both the increasing activity of cyber criminals and also their increasing sophistication. So just by way of example, shortly before Christmas, there was a lot of activity particularly focused on law firms. So a couple of law firms around Queensland lost millions of dollars through this type of cyber attack. And what was happening is that they use various methods of actually getting the passwords to access your system. And rather than doing something immediately that you would become aware of, they were monitoring email traffic. And when there was an email between, say, a client of the law firm and the law firm instructing them to deposit money into a certain account, they would go into that email and change the account details to be their own bank account. So money was being siphoned out of solicitors' trust accounts into criminals' bank accounts, essentially, by what was a fairly sophisticated means. So there's been a whole raft of changes for our industry based around that activity, and a whole range of changes, and as will happen to you, I guess, increasing costs of actually running your business. So the reason why the government introduces these changes is that it's critical to our economy and at business that consumers have trust and confidence. It'd be difficult to run your business if your clients and your residents didn't feel that they could confidently share their information with you. So really, I encourage you to approach it from that mindset. Yeah, thank you. So what is the scheme? I mean, that word scheme is bandied around a lot. You've got retirement village schemes, you've got community management schemes. What does it actually mean? Well, really, it's just the name given to your series of what are now statutory obligations to notify affected individuals, as well as the Information Commissioner, about eligible data breaches, and they are breaches that are likely to result in serious harm. The graphic there has absolutely nothing to do with the data breaches scheme. I couldn't find an appropriate graphic, so it's got two of my favourite things, dogs and flowers. So what is an eligible data breach? That's what it's really all about. What triggers these notification obligations? So there's really three basic components. Firstly, you have unauthorised access to personal information, disclosure of personal information, or it could be the loss of information. And for example, that could be a staff member losing a USB that's got personal information on it, or a smart device that's got access to your system. The second requirement is that it's likely to result in serious harm to one or more individuals. So it really only takes one person or one of your clients, one of your residents, to be affected by this, and it will be triggered. It doesn't matter that it's not a whole lot of people or a whole cohort. And the final thing is that you've not been able to prevent the likelihood of serious risk with some sort of remedial action. So there's nothing that you've been able to do quickly which would save your clients from suffering this serious harm. So if we go to the next slide, begs the question, what's serious harm? So it really can be any form of harm. And if you think about the sort of information that could get out about your clients, it could really relate to just the type of care they're receiving, their medical history. Might not result in any kind of physical harm, but how would they feel knowing that that information, that level of detailed information about them was being shared with people they don't know, or potentially being made public? I think that this is where psychological and emotional harm is something that you're going to have to take into consideration quite a lot. The other obvious one is financial harm. Now, your systems probably at some level have bank account details of your clients. That issue is obviously a bit more live for financial services providers, but it's still a consideration for you. And there's really no limit on the type of harm. So it really requires you to consider how your clients could be affected by whatever information has been lost or accessed. And it requires you to make an objective assessment of what a reasonable person would think. Would the reasonable person think that this loss or access was likely to result in serious harm? Now, lawyers are really familiar with this concept of the reasonable person because it's had a long history back to case law at the beginning of the 20th century, where there was this notion of the reasonable person being the man on the Clapham omnibus. And Clapham was a part of London where your average working class person, what we might think of as the average bloke in the street, used to live. And so there's an assessment that you're meant to make as this ordinary everyday person. Not a person who's particularly religious, extremely intelligent, knows the law inside out, and not but someone of reasonable intelligence, knowing what you know. So in your position, knowing what you know about your clients, knowing what you know about your systems and the information that's been accessed, would that person think that there's a likelihood of serious harm to your clients? And to be a little bit helpful, the legislation has listed some relevant matters that you have to take into account. So on the next slide, I've listed those there for you. So what would the reasonable person think, taking into account, firstly, the sensitivity of the information? So is the information just a list of names and addresses, or is it something, as I mentioned earlier, a more detailed list of medications perhaps that your clients are taking, medical history, financial information? The number of security measures that you've got in place protecting the information. So, for example, if it's a smart device that has been lost, is it password protected? Are there further passwords that would have to be entered for a person to be able to access your systems? Is there some sort of recognition, using your fingerprint? Because I guess the more protection you've got, the less likelihood that there is going to be serious harm. Then you have to consider the person or persons who have obtained the information. Now, if it's a breach of your network systems, your IT people might be able to trace or get some idea of where the source of the access. And sometimes they can tell you that it's come from an IP address that's located in Eastern Europe. So that might give you a clue that you're really dealing with people who perhaps have got some sort of criminal intent. Or is it a case of the iPhone's being left in a train, and really it's, the chance of someone really sophisticated who can quickly get onto that iPhone and download a whole heap of information is probably less likely. And linked to that is this question of whether the persons who have accessed the information are likely to be able to get around whatever security measures that you've put in place to protect the information. And then there's a consideration of the nature of the harm. So, if financial information has been accessed and it's then pretty easy for them to be able to perhaps get into bank accounts or access credit cards, then that might be something that makes you act really quickly, as opposed to the harm that could be, the bad feeling it might leave for someone to for the list of names of your clients to be out in the public space. And then there's always there's this really helpful any other relevant matters. And in trying to think of an example of that to give to you, I was reminded of a complaint that I helped a client with, a community care client with a few years ago. They had some very strict instructions from an enduring attorney who was giving them, was contracting with them on behalf of an elderly relative about just who in the family was allowed to have information about the client. And it was all over the file about not letting the black sheep son have any information. Now, if you've got that sort of situation in place, you might have a different reaction to a PC losing a file or losing a smart device whilst they're in that person's home, for example, and there's visitors there. That might be an example of this other relevant matter that you need to take into account. So if we go to the next slide, I've put there, just really tried to distill all of these issues down into some really quick checklist for you, because as you'll see later on, the quicker that you can act in circumstances where you find out about a breach, the better it will be. So 3 things to consider: the type of information that's been accessed or lost, the circumstances surrounding the breach, all of those things about how it was accessed, what you can find out about it, what protections you've got in place, and then the nature of the harm that could result. So that's just to enable you to do a really, your quick initial assessment. Now, there is an exception to having to report the breach, even if it could result in serious harm, if you've been able to take remedial action. So this is before there has actually been disclosure that's caused reasonable harm, which is why I mentioned earlier that the quicker you can make some sort of assessment, the better. And if you can quickly ascertain, to the extent you can, that there hasn't actually been any disclosure, then there might be some remedial action you can take to make sure that There can't be any disclosure, for example, blocking a user's access to your system if a password's been lost. But what has to happen is that as a result of your remedial action, the good old reasonable person, again, would be likely to think that there's not going to be any serious harm. And I expect that this is going to be the exception that you deal with mostly. So it's about having strong systems in place that would enable you to quickly identify what's happened, make an assessment, and determine what remedial action you can take. On the next slide, I've come up with an example that might help sort of give some reality to all of this. So if we consider that you're a home care service provider, your carers are issued with mobile devices that enable them to access client information. That's a pretty common thing these days. It's really how your business gets to do what it does. So in our example, Kara has her lunch break at a coffee shop. She leaves the device at the coffee shop, realises that she's done so when she gets back to her car, quickly races back into the shopping centre only to find that the device is gone. She does the right thing, immediately reports it to you, and fortunately your IT department are able to remotely delete all information on the device within an hour of it being reported. So if we consider those steps that you have to go through, first of all, there's clearly been a loss of some information with that device being lost. Would a reasonable person think that there's the possibility of serious harm? Probably yes, given the detailed advice that, at least in this example I've said, is on that phone. You've taken some remedial action. You've been able to do that, and you've done that really, really quickly, within an hour of the report, particularly bearing in mind that in our example, she's reported it to you as soon as she has become aware, he or she, I should say, has become aware of the loss of the device. So I think in that scenario, with all those sets of circumstances, reasonable person is likely to think that there's actually not going to be any serious harm because of the remedial action that you have taken. It might be a little bit different if, for example, there wasn't any type of password protection on the device and anyone who picks it up could very quickly get access to whatever is on it. That might cause you to think differently. You might also think differently about this if she didn't realise until, if this was happened at the end of her shift, and she didn't actually realise that she lost the device until the next morning when she's getting ready to go to her first client of the day. Because in that scenario, there's been, more than 12 hours for somebody to potentially have access to the information. So regardless of how quickly your IT people can get to things done when you report it to them, the intervening delay probably means that you've lost that window of being able to avoid the notification. So if we go to the next slide, what we've been talking about up to now is where you actually know that there's a breach or you know that there's a loss. But it could be that there are circumstances where you just think that someone may have accessed your system because of some unusual activity that your IT people have picked up. So it's a mere possibility at this point in time that there could be some serious harm to your clients. What the scheme allows you is up to 30 days to conduct an assessment in these types of circumstances. It must be a reasonable assessment and it must be expeditious. And what that means is don't think that just because you've got 30 days, we don't need to start it until next week. If you suspect something, you need to take action as quickly as you possibly can to determine whether or not there has actually been a breach, and then to take those next steps about deciding whether or not it's a notifiable breach. And if you doing all the best you possibly can, haven't been able to complete the assessment within 30 days, then what you need to do is be able to document what you've done. So all of the steps that you've taken in that period of time, the reasons for the delay, and your assessment that what you have done has been reasonable and expeditious. Because what you're trying to do is avoid the situation where information is actually lost, someone suffers harm, you haven't notified, and therefore, and you might find yourself with a complaint to the Information Commissioner. You want to be able to demonstrate that you've done everything that you possibly can. And part of that might lead you to decide, look, we haven't been able to get to the bottom of it, but because the consequences are so potentially serious, we're going to notify. Or you pick up the phone and make contact with the Commissioner's office and see if they can give you some guidance, because it all is going to come back to the circumstances of exactly what has happened in that particular instance. So if we go to the next slide, it's up to you to determine what your assessment should look like if you've got a suspected breach. But the Office of the Information Commissioner has suggested 3 steps, and the first one's a pretty obvious one. Actually decide whether an assessment's necessary. And whether you decide whether an assessment's necessary might depend on the circumstances. For example, you could have an employee who loses a handbag or a briefcase on the way to work, and they fess up that actually all their usernames and passwords were in there. Something like that might, does that require an assessment, or do you simply get them to change all their passwords and change the usernames and, Bob's your uncle, we fix that. Secondly, then if you decide an assessment is necessary, you're going to have to investigate quickly, make a determination of all those factors that you would have to take into account when you're assessing. Has there been, what's the reasonable likelihood of harm actually resulting? So who could have had access? What information could they have had access to? Bearing in mind that it could depend on the pay grade of the person who's lost their username and password, because they may only have access to very basic information. It might not be your CFO who's got a much higher level of access. And then the likely impact on your clients, and then conduct the evaluation about whether, if you have got a breach, is it an eligible breach that requires you to notify. The next slide, I've got an example that we might use to give a bit of substance to that. So this time I've chosen a residential care facility. Your IT manager reports some unusual access to the system after running daily checks, and that is that your receptionist has logged into the account system at 3 a.m. Now, that's got to be something that would be particularly unusual, I'd suggest. And you speak to the receptionist to just confirm that she hasn't actually, that you aren't dealing with an employment issue. And in the course of the discussions, she tells you that her password is her surname. And just a word on passwords. I'm here as a lawyer, not as an IT expert, I realise, but one thing that really has been drilled in is that, passwords should never contain surnames, because it's too easy for people to go on websites, see who your employees are, figure out what the username is, and then just rattle through, options that involve their surname. And we certainly had that type of attack recently, and what would happen, fortunately, is our system would block us because they had their 3 goes, and the system throws them out, but it also stops us from then logging back in using our username. So, it really is happening. So password strength is really crucial to any of your planning around all of this. So if we've got this scenario, your first question is an assessment necessary? So this is where I mentioned that it might depend on what your receptionist has access to. It might also depend on what your IT department has reported to you that this instance of access actually got into. They may be able to trace and tell you, well, they didn't get very far, no harm done, but we need to fix a few things. If the investigation is necessary, then, you know, what information can your IT people give you about, you know, who made the access, what traces can they do through IP addresses, the information, as I said, that was accessed, and then consider the likely impact on your clients, and consider what protection you can now put in place through remedial action. But in all of that, make your evaluation about whether this is an eligible data breach. So I guess that's just an example about how it could all play out for you. So the other exception that you might come across, as well as where you've taken remedial action, is where another entity has actually had to do the assessment and then the notification. And the best example that I can give is where you actually use a cloud provider. So all of your information, personal information, is not stored on a network or servers within your own building, but is actually externally on servers that are owned by your cloud provider. Could be in the same city, but could also be in another state. But equally, even though I've used the example here of a cloud service provider, it could be any one of a number of your service providers that you actually share information with about your clients. It could be an ACFI consultant, for example. So if that service provider, if it's their system that was breached, but in that breach they've actually accessed information that you have collected and given to them, but they conduct the assessment, there's really no need for you to do the assessment. And it may be even that they have the obligation to make the notification, because in this scenario, arguably both of you have got an obligation to make notification to the individuals who are likely to suffer serious harm. So the question for you becomes is, do you want those service providers being the ones giving notification to your clients? Or do you want to have control over that and thereby making sure that you protect the relationships with your clients, but also ensuring that there's no chance that you haven't complied with your obligations because you've just left it all to the third-party service provider. So all of those potential risks for you, I think, should trigger at this stage questioning about whether you need to put in place any additional arrangements with your service providers who you share information with. Does your existing contract with them, for example, require you to notify them if there has been any loss of information that you've given to them about your residents and clients? How big are they? Are they obliged to comply with the privacy principles? Probably something you should have asked before this point, but you know, it's a good opportunity to go back and check all of those things. And I think at a minimum, you'd be wanting them to tell you if they have any circumstances that they become aware of which cause them to suspect that there's been a breach of their systems or a loss of information, or where they have actually actual knowledge that there's been a breach or loss. So that enables you to make an assessment of what the risks are to you and your residents and clients. Also, if you're requiring them to notify you and to do whatever you reasonably require of them as by way of response to the breach, it gives you far better level of control over ensuring, A, that you're complying, But again, it's about protecting the relationship between you, your residents, and your clients, and also being able to manage any reputational risk that might be associated with the loss of information. Because remember, we started the presentation with the importance of your consumers having confidence in being able to trust you, and acknowledging that they already trust you, probably with far greater things being their care than just their information. But it's important that they be able to trust you implicitly on this. So I think that this area of your arrangements with your service providers who you share information with is going to be really a critical step in assessing what you need to do in being prepared for the start of the new scheme. So if we go to the next slide, so you've been through all the assessments, you've identified that you've got an eligible data breach. So what do you do? Who is the mandatory notification to? So there's really two steps to that. Firstly, you have to give notification to the Australian Information Commissioner, and you also have to give notification to any individuals who are at likely risk of serious harm. So obviously that's probably going to be your clients and residents. But of course, for aged care providers, that introduces the whole other question about who do you notify if you've got residents or clients who don't have full decision-making capacity, don't have the capacity to understand the notification that you're giving to them, let alone be able to assess the risk to them and what next steps they might need to take to protect themselves. So again, it's going to bring into play the whole checks that you need to have around who do you contact in these situations, who is the authorised decision maker for people who lack capacity. Even if your clients and residents do have their own decision making capacity, do they have family support who you also need to notify in these circumstances? Because just for example, I've been doing a lot of helping out with my husband's family at the moment. His mother is receiving a home care package. So we've got it set up that Pam is completely able to make all of her own decisions. So, the service provider can communicate with her about all kinds of issues, but it's her preference that they let us know what's happening as well. And so that's all recorded in her care plan, and that's the way it works. So it's not necessarily just a case of whether or not your client or resident has got their own capacity to understand these things. It's also thinking about, just who is it that you should be advising as well as them. If we go to the next slide, so the notification to the Commissioner, the legislation does say quite a bit about what has to be in the notification. So it's got to be a statement, as you would expect, all details of your organisation's identity and who do they contact to ask questions about what's gone on, a description of the eligible data breach, so whether it's been an access to your system or a loss of some sort of device, type of information involved, and probably the trickiest one, what steps you recommend individuals take in response to this breach. And that's probably connected to the type of information that's been involved. Again, to go back to our old example of, financial information versus information about medical histories and medications, probably different things that they need to do. Another example is in the home care sphere is if the information would enable someone to determine when that elderly person is home alone. So, you've obviously got the physical threats that come with that. So that's another consideration when you're thinking about what response to recommend. Now, to help you with all of this, there is actually going to be an electronic form, and on the Commissioner's database, there is a draft version of that form. I imagine they must be getting pretty close to issuing the final version, but that, if you want to have a look at it, that at least gives you an idea of what what you're going to, how you're going to have to give the notification when you start planning your response to all of this. If we just go to the next slide, which is about the notification to individuals. So firstly, it's to the Commissioner, but very quickly thereafter, you have to also give notification to the individuals who are affected. Now you've got some options here about how you give that notification to the individuals. You can just give it to everyone who's involved, which could be a whole resident cohort, for example, or it could be to only individuals at likely risk of serious harm. And that might be a distinction, I used earlier the access to financial information. So you might be able to, through your system checks, determine just which residents you've got. Maybe you've got credit card details for payments coming out of a family member's account that way, and that information is the information that they access. Then you might just make a decision that really it's only those people whose bank accounts or credit card details were accessed. As opposed to if it was just blanket access to all of your care plans and details about medical histories, then you might be stuck with having to give notification to everybody. And the final option is to publish on your website and to otherwise publish the fact that you had the data breach. Which raises that whole reputational risk issue again. Now, I suspect that these requirements are more directed at large listed entities providing financial services like banks and credit card providers. It could also relate to, I know that I've had a notification from a multinational organisation that owns hotels throughout the world, and their database was accessed. Of course, they've got a lot of information about how you paid for your room, etc. But if you're working for one of the larger listed providers, that might unfortunately be something that you have to do depending on the extent of the breach and how much was actually accessed. But if you're a provider with a single facility, my thinking would be that that's probably a bit over the top in terms of what you have to do. So just to reiterate the timing of when these notifications have to be given, because that's obviously crucial to managing the harm that can flow from the data breach. So with the Commissioner, as soon as practicable after becoming aware that you've got reasonable grounds to believe that there is a breach, which brings you back full circle to what I emphasised earlier about conducting the assessment quickly if you even suspect that there's been a breach, and in individuals as soon as practicable after you've completed the statement to the Commissioner. So whilst you're preparing that statement for the Commissioner, you might also like to give consideration to what parts of this would we put into the notification for the individual. The next slide, what I've tried to do here is to give you a bit of a summary of the actions. The Commissioner has actually put out a much more detailed, I guess, checklist, and I've got some copies here to give to those present, and we can certainly email copies to anyone who's listening in on the webinar. So your first port of call is that we've got obligations to protect the information that we hold. So is the security of that information sufficient? And the first you're going to know about whether or not the scheme applies to you is the possibility of a data breach coming to your attention. So you take immediate steps to contain the breach, firstly, and to make sure that you're minimising any potential harm. Then you conduct your assessment, work out if the breach is likely to result in serious harm to individuals. If it is and you can't take any of the remedial action, then you must notify. If you form the view that there's no likelihood of serious harm to individuals, you don't have to notify, but what you really should do is conduct this review of all of your systems and processes to make sure that, coming full circle, you have got adequate security of the information that you hold. If you conduct the assessment, you take the remedial action, but you form the view that despite your best efforts, there's still possible to form a reasonable view that there's a likelihood of harm, then you still have to notify, even though you've done your best. But if you take your remedial action and because of that there's not going to be the harm, then we're down to review again, to review your security. And also you need to review your response to what's happened. Was your response adequate? Was it quick enough? Is there anything we can do better next time? On the next slide, I've given you what I suggest might be a to-do list following on from today. First of all, to review the protections you've got in place for personal information. That comes back to password security, password strength, smart devices, how many protections have you got there? What's your ability to respond? Can you remotely wipe information? Particularly if you're a home care provider, can you remotely wipe information on these devices? Review your privacy policy. Do you need to make any changes as a result of what you're doing in response to the scheme? Really critical one in my view is to check your arrangements with your suppliers, contractors, consultants and community partners, anybody that you share information with, to make sure I think that at a minimum they're required to tell you if they suspect a breach or have a breach. Importantly, prepare a plan for what you will do if there is a breach. Who is the person or the group of people in your organisation that's responsible for receiving notifications about suspected breaches? Who's got the authority to begin an investigation? How's that investigation conducted? So you can quickly pull the team together so that you can respond appropriately. And cybersecurity training. I'm sure the last thing that you want is to have to provide further training to your staff, but it's unfortunately becoming critical, and it's unfortunately becoming something that you have to do regularly, because the weakest link really probably is staff members who unwittingly share passwords or information that enable someone to gain access. Hope that's been helpful. My pearls of wisdom. I think we're about to lose everybody on the webinar, so I'll respond to any questions that have come in, and I'm around here for a little bit longer, so I'm happy to take questions.
Thanks, Joanne. And just before we move on to questions, just if people are still online, are they still online? They can also email me, and I'll make sure that we collate the questions to Chris E, CHRISE at lasa.asn.au. Thanks, Ange. And again, before we go into the question time with Joanne, would anybody mind if we will object to having photos taken, a couple of photos taken? If you do, raise your hand. Otherwise, are you okay with that, Joanne?
Yes.
Okay, thanks.
So around the table, anyone got any questions, comments, concerns, want to talk about anything? Makes my life easy.
Very clear. Yeah.
Look, if there's anything that occurs to you after you leave today, when you get back, and you start to think about things a bit more, and you've had time to let all the info sink in, please contact Chris, or you've got my contact details. I'm happy for you to email me any follow-up questions that occur to you later.
Hey, Joanne. Joanne, it's Sandra Glaster. I just sent you a message online. I'm not sure if you saw it, but a question with regards to staff information, because many services, particularly after hours, will have staff telephone numbers and the like handy for after hours staff replacement. Does the legislation control the storage and access of that information too?
Look, Sandra, it would be personal information of your staff. There's no question about that. But I think there's probably other obligations that you would have in relation to your staff, which are probably more pressing in terms of your obligation and your duty of care to your staff. But you know, in terms of the eligible data breaches notification, I think that you probably would find that the remedial action that you could take if you became aware of that would mean that there's no need to notify the Commissioner. But I think that you should always notify your staff where there's been access to that level of personal information about them, and to give them the ability to make the decision about whether they want to change phone numbers, for example. Does that help?
Thanks, John. I just asked the question because I am aware that, you know, from working in the industry, as many of you have, that there have been occasions where other people other than staff have got staff phone numbers and have contacted them inappropriately.
Yeah.
We've had a few informations about the presentation being distributed.
That's it's no problem about I think Chris will or Paul will probably arrange for the presentation to be emailed around. That's no problem.
And there's a question about, is there an issue with treating doctors to have access to the IT system off-site?
Well, there's technically no issue about that, because first of all, remember that you're allowed to use personal healthcare information that you obtain for the purpose for which it was given to you. So enabling a doctor to access that information is clearly within the reason why the individual gave you the information in the first place. The question then rises about whether you've got adequate security for that personal information. So, you know, how does that doctor obtain access to the information? Is he allowed to do it over an open network, for example, which is not secure? Is he or she required to use a password? What's really becomes important there, I think, is the protections that you put in place.
Thanks, Joan. We've
got
a question here as well.
So when it comes to notification to individuals, and you were speaking about publishing on the entity's website and so on, we make these reports to the Commissioner if we have a breach. Do we get recommendations back? So is it, you were saying, depending upon the entity and those sorts of things, would it be the Commissioner's position to come back and say, and given the you know, the size of or the nature of the breach, that we want you to publish it on your webpage, or in this instance that's not required?
No, that's a decision for you to make.
Right.
As to what's the adequate disclosure. Yeah. You would only get the Commissioner coming and directing you to do it in a particular way if there's been a complaint about what you did do, and the Commissioner, after investigating, informs of you that what you did wasn't adequate.
Right.
But don't be hesitant about if you think you need some guidance. You know, there's lots of information and from the Commissioner available as to give you guidance.
Is there any potential for the Commissioner to then report to the Department of Health, which could then affect our accreditation?
Yes. No, there's no. The privacy legislation doesn't contain any sort of direct obligation on the Commissioner to report anything to the Department of Health. I can't see that he would want to get involved in that kind of regulatory area, and it would probably only come to the department's notice if there was such a severe breach that it was in the public domain, or you obviously had a client, resident or family member who makes a complaint to the Aged Care Complaints Commissioner. That's probably the more likely route for it to become a compliance issue through the aged care regime.
We've got another question online. Alice has just mentioned if obtaining ACFE information from a previous facility, they usually get it by fax. Is that an inappropriate way of obtaining information?
That depends on how secure the fax line is really. I don't. The legislation's not much help about what is adequate security and what is risky and what isn't risky. You've got to make an assessment of that based on your systems and the protections that you've put in place. And I guess, you know, the immediate risk that comes to my mind with faxes is that sometimes they, well, depending on what your system's like, they sit around on a fax machine, or more likely these days, faxes actually come through the internet. So it depends on how secure your internet systems are.
Another question was, what do they do if there's a breach in the cloud? People say that there's a breach, but the wording is ambiguous.
I beg your pardon?
It says, what do we do if a cloud provider says there is a breach, but the wording is ambiguous?
So if you get any kind of notification from a cloud provider or a service provider that there's a breach, there's a suggestion of a breach, what I think your first immediate response would be to require them to investigate it and give you more detail, and to do that quickly. And that's why I suggested as one of your actions to go back and check your arrangements with those service providers, because you don't want their response to be, get stuffed, you can't tell me what to do, and, you know, my systems have been breached. You actually want to be able to require them to give you the information you need and to conduct a proper assessment, which would enable you then to assess, you know, what the likely risk is to your clients, residents, family.
There's no other questions coming.
Okay, thank you, everyone.
Joanne, I'd just like to thank you on behalf of Kerry, Paul, myself and the laser team here in Brisbane. So thank you so much for coming along today. It was a really clear presentation, very simple, very easy to follow, and great objectives. So thank you so much for your time. We will make arrangements to get the PowerPoint presentations to members. Or to people that have paid to come along today. So anything else around Joanne's presentation?
I'll just leave with Chris also. I mentioned when I showed you that summary slide of mine that there's a much more detailed one from the Commissioner. Really didn't want to try and put something like that up on the screen, but there's 25 copies there, so take one of those if you like. I think that would be helpful.
Is it possible to email?
Yeah, I'll email that to you.
Yes, lovely. Thanks,
Please
Joanne. Yeah, okay. All right, we'll hand it these out. So
thank you.
Thanks very much.
Chris, might be worth just saying, I think that the comms team will probably put this link in Thursday night's e-news.
E-news, yes.
Plus any of the other documentation will come out in e-news on Thursday night. So you'll be able to access it easily.
So I'll just leave a copy up here for the hard copy that Joanne's provided. And then for those of you that are staying on for the Residential Care Advisory Committee, that's starting in the 20 minutes. Thank you again.